Welcome, my name is Rachel Brinke. I am managing partner and head attorney at Eden Law, which is an intellectual property law firm. I work with creatives and creators of all types, from authors, photographers, web designers, YouTube creators, all the things, right? Because the main thing that we all have is intellectual property, which is the content or the things that we are creating that either it's for fun or it's our livelihood. Either way, we want to protect it all. And you know what's funny is I was preparing for this morning and going over my notes and thinking about it. I often get into these whole, it's like on the movies where there's like a pause and it goes into a daydream, right? I do this a lot, just thinking about how much I love intellectual property, and I love that my path in life has brought me here because there's so much that we do. I mean, think about it. We go to movies, we listen to music, we read books, and we do all these different things, and it's intellectual property that we need to protect, that we need to make sure that we're on top of. However, even though we have the tools here in the US to do all of that, there's people out there, entities out there that are scraping, stealing, pirating, and taking away from us, right? Whether it's our livelihood or it's something that we just love, they should not be taking it. So we got to figure out like what we can do. And you know, it's a bummer really that we have to be on the offensive in order to not take, like we learned that in kindergarten, do not take what's not yours. But I think with the advancement of technology and with the advancement of social media, especially since the pandemic, we have seen a lot more of intellectual property being taken and used from memes and GIFs, and obviously through scraping sites that take blog posts, books, etc. And so sometimes it's really an entity or a person that just doesn't know, right? That's not necessarily a defense. They didn't create the property and they didn't get permission, so they need to be looking out for that. More often than not, infringement type stuff is going to be less of an intention, less of a nefarious type of intention, but that's where piracy comes in, where there's entities and people that are doing things that they know is wrong. And so we do, that's part of being a creator. We have to take the offensive and get tools in place. So I'm going to give a quick rundown on the tools that we have here in the United States, and then also some of the top questions like how do we combat this in the United States, out of the United States, what happens if those tools fail. But yeah, so I am going to dig into that in a second. But if you have any questions after this, please feel free to reach out. My law firm's email address is eden-law.com, or you can just search me, Rachel Brinke. I'm the only one on the interwebs. I've got multiple sites. If you just get confused, you can submit through any of the contact forms, and my teams all work together. It's incredible, amazing, and I love it. I'm mostly saying that because they are watching this on the live recording. No, but they are. So they will get it to me, or at least get some resources to help you out. Before we go in, of course, I got to do my little fine print as an attorney. I am a lawyer, but I'm not your lawyer unless you want me to be, in which case we can do at eden-law.com. However, all of this information is general legal information. A lot of what we're going to talk about is federal level stuff. There is some state specific potentially that could come into play, like if you're in contracts of publications and stuff like that. But for the most part, the information fairly travels well. It travels well. It translates well across all of the United States, the different states that we have. But just understand, don't fully rely on this because your very specific circumstances or facts of your case might vary. I might try to share some of my client stories without giving away of information. I have permissions from some too, but I definitely want to try to make this as fun and entertaining. Although, legal, it's one of those things you don't want to have to deal with. And I feel you. I absolutely hate that we have to be on the offensive, but let's just dig right in with the tools that we're going to use, right? So in the United States, we're looking at creating of like blogs, books, and anything of like text of that nature, even visual assets. So it could be book cover that's created. It could be your logo that you use. All of that is going to be protected through copyrights. It's actually protecting the actual artwork or the actual text itself in the way that it is. The word structure, the sentence structure, all of that in the way that it's presented in one form is through copyright. One of the good things in the US is that when we create it, right, we're not working for someone, we don't create it in scope of work with them, you don't have an agreement saying anything you create during your employment with someone. We as the creators, the ones that write that book, the ones that take the photographs or illustrate that cover, we are the ones that own that unless we are employed by someone or we contract that away. because you can convey it and can sell it off. And that's typically what happens if you get in with like a publishing house. You'll either be looking at selling the copyright. Think of it like a title to your car. You'll be signing the actual ownership of the car from you to the publishing house, or maybe just a license many times, and you can negotiate. I do this for clients. I've done it for myself as well. I have multiple books where I retain the ownership. So I retain ownership of the car. I'm like a car rental company, and I'm just extending the publication, that permission to use of that car, or the text, or the cover, or anything else for marketing and use and sales of the book, right? So copyright, we have that protection upon the creation of that in the United States. The downside a little bit is that copyright is really not truly favorable. And what I mean by that is we have these protections. You can pursue infringers, people that are using this book for commercial gain, people that are pirating it, and all these sort of things. You can pursue them. But when you have just this, I wrote it, or I took the photo, or I illustrated the cover, it is a common law right, and it's not as strong as if you take the steps to register it. So I always recommend that we register with the Copyright Office, copyright.gov. We're doing the actual book itself, all the text, like the manuscript aspect, as well as the cover and any others like your diagrams, graphics, or whatever that you have included. We want to get that registered at the Copyright Office because it's one of the things that we can do be on the offensive if we need to pursue an infringer and we can touch them, which we're going to get to talking about what do we do if we're not able to pursue someone. But if we are, then we have on our side this immediate threat. With registration, there's an immediate threat of going to court if we need to, right? But it's not even so much that we're going to walk into a federal courtroom. It's just this idea of being able to lean some strength on them to push people into settlement, to stop their behavior, what they're doing. So you got that immediate threat of litigation on them, as well as attorney's fees. And I think this is a conversation that I've had probably with some in this group and outside of it. We have it all the time with our clients, and it sucks, right? This is our copyright. This is our work. This is the stuff that we should have. Why are we having to pay out for it? Well, one of the tools that you can utilize is registering copyright. It's kind of like insurance a little bit in a way, in that if you do end up having a copyright case with registration and there's infringement, you're entitled to attorney's fees. You're entitled to request those and get those. You know, there's this misnomer that if you pursue someone and you win in a court of law, that you automatically get your attorney's fees paid, and that's not the case, right? So it's just really those two major points of having registration for copyright. There's other benefits as well, but those two major ones really lends us into a good offensive position when infringement happens, because it's not if, right? It's when. We go against major corporations all the time for taking primarily photographs or videos from clients, and it's good to have those two leverage points. Okay. You also can look at having trademarks. This is if you have multiple books, you have a series, can't just do one singular book, but trademark is also done at federal level, and it indicates where your goods or services are coming from. Think like Nike swoosh, right? When I see a pair of shoes with Nike swoosh, I know that those shoes hopefully are coming from Nike, right? It's what's called a source indicator. So you could have like a general business name. Probably most often authors will use either their name or a series name, and that is going to be that is the signal, that's the source indicator of where those books or other materials, goods, or services are coming from. The good thing about us also not only having protection of the actual work itself, but also protecting of the source, is that when stuff becomes distributed, we're starting to pile up all these different things that can lend some strength and argument. Because like the little nugget I threw out earlier, we may not be able to financially go to court. We may not be able to physically go to court. Just the time, money, and energy of having to deal with litigation. Ugh, I'm an attorney. I love it for y'all. But if I had to do it for myself, I'd just be like, ugh, it's so stressful. And it'd be taking away from writing books. It'd be taking away, especially if this is your livelihood of building up any sort of empire, if you will, and because you'd be focused on the litigation. And so again, we're wanting to try to pile up as many type of claims that we can make against someone. And when I say someone, it can be an individual or entity, because we want to leverage them into settling and stopping the behavior, right? So copyright for the actual protection of the works, trademark for protection of the source that it's coming from as well. And then, of course, whatever type of contracts we get into, like if you're distributing through Amazon, if you're utilizing, whether you're distributing through Amazon or printing through Amazon, they have some variations of terms. making sure you read and understand them and you agree to them. Now, Amazon's not one of those necessarily that you're going to be able to negotiate with. It's a take it or leave it type of deal, right? Whereas you get to a publishing house or a self-pub house, right? They have the halfway where you pay for a portion, the publication house pays for a portion. Those contracts can readily be more negotiated. Like I mentioned a little bit ago about retaining the ownership for myself and licensing it to a publishing house, that is something that I have negotiated in the past with kind of one of those hybrid self-publishing/publishing houses, right? So contracts is another tool that we want to have in place. Now, I understand that is a lot of information, overwhelming, but I wanted to give you that little tidbit of these 3 tools for us to be able to understand what we need to have done at least before infringement, right, or piracy, or any of these actions happening. And there is a difference in infringement and piracy, and we're going to get into that here in a second. But we have to know these tools in order to know how we're going to respond. Well, actually, let me back up. First of all, to set ourselves up for success, or at least potential success, getting us a fighting chance when we get in that ring, but also so that we can have tools that work in our favor when this happens, right? Because it's going to be when, it's not if. We see these cases all the time. It's all over. You're not going to be able to avoid it. So I really strongly encourage, look at investing in copyright registration and trademark registration if it is applicable. And then if you get into contracts, always have a lawyer review it. Now, let's start with just US-based. Let's say that you find someone, entity or individual, is distributing your book, right? We're just going to go with just the text of the book right now. And they're distributing it, whether it is, well, I guess they would just have to take the manuscript or even just segments of the book, and they're distributing it without your permission, right? If it is being used in such a way, we have a plethora of options. Well, not a plethora, but think of it like a sliding scale. Well, first of all, you could do nothing, right? There's nothing under the copyright law that requires for any sort of pursuit of an infringer. So you can electively choose to go after someone. Now, if they are infringing on your trademark, so it's like your series name, which is on the book, it's on the manuscript and all of that, and you've done a trademark, you do have a duty to pursue, okay? But on the copyright side, you can decide to do nothing or to do something about it. And the fact that you're watching this means you're probably, or at least going to consider trying to do something about it. The next step, most of y'all already know, is a DMCA, which stands for Digital Millennium Copyright Act, which is the act that helps to allow us to get our intellectual property taken down off of sites that are unauthorized, or just like a takedown notice. You've heard about that before. All the social media have it. ISPs have this. It may look differently, but they all pretty much need to comply with the requirements that are in the DMCA. Here's the downfall. ISPs in social media, they don't necessarily have to comply. And why I'm like kind of trying to choose my words on this is a website, or say like YouTube, right? I go and I post a video on YouTube, and you submit a DMCA against me through YouTube and say, hey, that's my work. YouTube will take it down and send me, the infringer, the notice, and I can respond to YouTube and go, no, wait, it's mine, and lie, and YouTube will put it back up. Because these platforms, these sites, are not able to adjudicate. They're not able to be a decision maker. Now, they're not supposed to, or else they can be liable if because they can be perpetuating infringement, right, if they choose wrong. And unfortunately, we still see cases all the time where the social media sites and ISPs are deciding who they're going to listen to, right? We see this a lot, and it's unfortunate, and the only way that they're going to stop doing that is if you do have a situation where you send a DMCA and they do not comply, or you see that the platform did weigh in favor of like me, the infringer, versus you, and you know you have the rights, it would be on you, the copyright holder, to make the claim against them and to really do a legal report, right? Going to courts and going against, that's the only way that that's going to start getting changed, is if we are able to step up. The downfall of that is time, money, and energy, right? So this is really where we want to look towards associations and stuff that are going to be able to stand up and have the resources to do that. So DMCA is an option. Now, I want to put a little caveat here. I don't typically jump to doing a DMCA if I'm looking for potential monetary recovery. So let's say, because I've had this happen before with my own books years ago, that they got a copy of the PDF version, of the manuscripts, and they were selling it, US based. Now, while I was going up the scale from like nothing, DMCA, demand letter, potential litigation, I sometimes will skip over the rung of DMCA because I want to be on the offensive if I know I'm going to be asking them to take it down and pay me and to stop their continued behavior. I'd rather my first communication with them alert them be directly from me after I've done all the evidence gathering, because like a DMCA sending would alert them that I know about it, right? Oftentimes we'll keep the DMCA as like a ace in the sleeve or in our back pocket. So if they don't comply to our letter, which is the third rung on here, sending a letter, because under copyright law, you are owed for actual damages, losses to you, benefits to them, and so you can do a letter. But of course, if those fail, or you just want to skip right up the ladder, take the elevator to the top, you can file in federal court. Now, that's just US based. What do we do if they're outside the US? Now, there are some countries, we have like UK, etc., some good amount of the EU countries that we have conventions with that allow for, in a colloquial sense, this isn't the exact words, but allows for almost us to reach through that that paperwork that the US has with these countries and reach into their country and apply our copyright, our rights, onto their citizens or residents that are utilizing, infringing on our intellectual property. So this can be copyright or a trademark, in fact. Now, the big question that I always get is, what if they're not in one of those countries, right? Because if you're one of those countries, you'd go through the same analysis we just talked about, the same steps. The unfortunate thing is we're seeing the majority of infringement and piracy happening, and piracy really is more so of just distributing, right? We've seen this, just scraping it off of Amazon, out of Kindle, out of those programs, and they are just distributing it onto the internet. And what I'm finding is sometimes the sites are monetized with like AdSense, etc., and that helps us to kind of reach a little bit more to them because they're utilizing Google and Amazon, which are US-based stuff. So sometimes a little bit more teeth to our threats, but if they are purely in a country, and we really see this over in a lot of Asian countries where we don't have any reach into them on this sort of matters, right? We have no legal reach in. There's really not much we can do. So that's why, actually, when you guys come to us with this sort of stuff, we go through and try to see how can we reach them, right? What servers are they using? Amazon? Boom, we go to Amazon and not the person that's distributing, right? Are they hosting with someone here in the US? Like, we try to look for those sort of backdoor ways that have a tie to the US. Some completely don't, and it's unfortunate. And actually, I'll give you the list of unfortunate things here. For in the US, if these you send an infringer a DMCA, it can unfortunately get put back up, like we mentioned. If you send a demand letter, they can simply ignore it and walk away. That's unfortunate, right? You're then forced to deciding between nothing and litigation. Now, when it's outside the US and there's no real way you can reach into them, unfortunately, I know this puts you guys in a weird predicament, because Amazon has in your agreement, like back to what we talked about, knowing what's in our contracts, our tools at the very beginning, that they have exclusive publishing rights. You agreed to that, right? So this is something, I want to say, unfortunately, we can't do much for other countries that we don't have a reach into. At least now, I'm hopeful that as we move along in, hopefully the law will catch up with technology, but we always have this friction. There's other countries that gotta want to work together, and if they don't, they don't. And right now, they don't. This is also just as an aside, if you're ever looking at publishing or manufacturing, I know it's cheaper to go over there, please don't. Because we actually have 2 current clients that have done manufacturing over there who have had major issues that those manufacturers are turning around and distributing to other people, and it's very hard to touch the manufacturer. We're having to try to pursue the people that it was distributed to, and it's a lot looser and weaker argument going after them, okay? So again, US, got the steps. Outside the US, look for what you can, what we can do, but what do we do if it's impacting like our relationship or our contractual obligations to Amazon? This is one of those places that I think having a lawyer, and again, I'm not one to say rush to a lawyer. That's why I gave you these ladder of options. None of that really requires a lawyer. Nothing requires you to have a lawyer to do any of that. Is it helpful for evaluation and strategy? Yes, right? And when a letterhead from a lawyer comes in the door, it's just got a little bit more teeth and heat behind it than it just, and I won't say just an author, but I feel like sometimes that's the way infringers view it. And so my point is for the Amazon response. If Amazon comes to you and is like, oh, but we have exclusive publishing rights, I think this is where you outline a lot of the analysis that we just talked about, right? A very well thought out response of, I didn't distribute it, etc. Is that going to be foolproof? I don't know. I don't think it's going to be. It could be. I think the reason that I'm hesitant on to say, yeah, that'll work, yeah, it won't work, A, it's going to be fact specific, and B, it's also going to depend on what representative at Amazon is managing and reviewing that, right? We see this a lot in like e-commerce type situations, people with chargebacks, and you're having almost sales level reps, phone call level reps that are evaluating legal stuff, and they really shouldn't be. And so there's not really a continuity in consistency in the way that, you could get one rep at Amazon, if you ever gave it that, ran into the situation, who goes, oh yeah, got it, we know you didn't do it, you did what you could, you sent demand letters. Again, another reason for all these list of tools we talked about, instead of just doing nothing, you're able to pad to show Amazon, hey, I didn't do this. Here's where I'm trying to defend my rights. I can only do so much. But you could get one person that's like, okay, cool, thumbs up, we're not going to bother with you, author. And then you could get someone else that is not necessarily going to apply it across the board. So for me, like we talked about, know the tools, know the steps, the options available in the US, out the US, and just be prepared with all of this evidence and an argument to make to Amazon. I know that's not the best answer, but again, the landscape of copyright is so incredibly benign, because with it being created, we've got little patches. It's coming into the future a little bit, or the present even, not even the future, is that it didn't contemplate the mass distribution that we have these days, especially when it comes to like AI and these scraping sites and all these type of scripts that can be run and can make it so easy for piracy and infringement to happen. So we're getting there. So please don't feel completely dissuaded by it. I don't want this to keep you from creating content. Just know the tools that we talked about, have the options in your mind of what you're going to do, and set yourself up for when this happens, because it's when and not if.